Donald Trump slams Judge Engoron's final report. He got this from a monitor, an independent monitor that Judge Engoron, you may remember him as Areola, aka the Nip, seen here sitting next to his GF, his Greenfield, on the same level on the bench. I don't know what's happening under the bench there, but the point is they have been colluding for quite some time, along with Tishy Tish James, to punish Donald Trump for daring to do business in the state of New York and for daring to be Trump. And so what happened, of course, is we've covered the full trial here. We're waiting for Judge Engoron to issue a ruling on this thing, like any day now, Judge. But what he has waited for are these final reports. This is a report from the New York Monitor. We're going to see her. She's a retired judge. She put together this kind of a short document. We'll hit the highlights. But then Trump turned around and blasted this thing. He says, you know, everything that you put in there is either inaccurate, it's irrelevant, or it's de minimis. It's minor. It's a clerical problem that doesn't account to anything. And so all this is going to go to the judge, and then he's going to make a decision about what to do, about whether Trump's entire business should be evaporated overnight in the state of New York. Now, Alina Responds is going to also come and explain some background in her take on this, but this was a wild story from the AP, republished by ABC News. Look at this. They admit the truth. They say taking away Trump's business empire would stand alone under New York fraud law. Oh, like almost like he's singled out. Yeah, this was written by this guy, Bernard Condon, over from the AP. So shout out to Bernard for actually doing some journalism and some research. He says from New York, within days, Donald Trump could potentially have his sprawling real estate business empire ordered dissolved, okay, by the Nip, Areola. He just says, well, you're a fraudulent person. Dissolved. All of the millions and billions of dollars that Trump has created in new value for the state of New York, some psycho judge, after being prosecuted by some psycho AG, are going to dissolve it because these people know nothing other than destruction. So they say it's going to be dissolved for so-called repeated misrepresentations on financial statements to lenders. Adding Trump to a very short list of scam marketers and con artists and others. Now, the AP, to their credit, they did an analysis of nearly 70 years of civil cases in New York. And the penalty, dissolving this dissolution, has only been imposed a dozen previous times. And let's see what some of these other people who had their businesses ripped away from them, what that was about. Now, Trump's case stands apart in a significant way. It's the only big business found that was threatened with a shutdown without showing any obvious victims or any other major losses. Isn't that weird? Nobody's even complaining other than Tish. Banks are happy, Trump's happy, no victims. Shut your business down. Now, lawyers for Tish in the Trump's month-long civil trial have ordered that the principles of fair play in business alone are enough to justify the harsh penalty. In other words, Trump got some good deals on loans. But some legal experts worry that if the judge goes out of his way to punish Trump, it could make it easier for courts to wipe out other companies in the future. Columbia, this guy said, this is basically the death penalty for a business. Is he getting his just desserts because of the fraud, so-called, or because people don't like him? So AP went back, they reviewed 150 reported cases for this repeated fraud statute that was passed back in 1956, and nearly every previous time that a company was taken away, victims and losses were key factors, except with Trump. Customers previously had lost money, they've bought defective products, they never received services that they ordered, they were actually cheated, they were actually angry. Businesses were also taken over almost always as a last resort. At the end of the line, they were trying to stop a fraud in progress, like the business was still committing the fraud, and it's to protect potential victims. We have no victims in this case, not one. They included a phony psychologist, okay, so this is when they took this dude's business away, a fake psychologist sold dubious treatments, okay, a fake lawyer sold false claims he could get students into law school, and businessmen who marketed financial advice but instead swindled people out of their home deeds, right? Actual fraud. Now, in Trump's case, his company stopped sending exaggerated financial statements about the net worth years ago, but a court-appointed monitor noted that was only after he was sued. Now, although the bank offered Trump lower interest rates because he had agreed to personally guarantee the loan, it's not clear how much better the rates were because of the inflated figures. The banks never complained, and it's unclear how much it lost, if anything. Did the bank lose a dime? Bank officials called to testify couldn't say for sure if Trump's personal statement even had any impact on the rates. This dude is a real estate lawyer. He says this sets a horrible precedent. He says he once successfully sued Trump. Now, the question is about this dissolution. In an order last September that's currently on appeal, Engoron, Areola the Nip, said that Trump had indeed committed fraud and he should have his state certificates revoked. In other words, you can't do business anymore. Now, we don't know what he meant by dissolution, whether he's going to require liquidation, but this is wild. The AP analysis based on a search of these types of cases found victims and losses were factors in all of these other claims. For example, a breast cancer nonprofit was shut down years ago. They used $9 million of its donation to pay for director salaries. Yeah, they said, we're going to fund free mammograms, and they paid themselves. They got shut down. Fraud. A private equity firm faking big investment successes was closed down. They literally stole millions of dollars. A mental health facility, they looted $4 million from public funds while they literally neglected patients. Now, there may be more, but legal experts say that these cases never show up in legal databases because they're settled or dropped. The only case that the AP found of a business dissolved without citing actual victims or losses was a small company in 1972. They wrote term papers for college students, okay? The Attorney General said the victim was, quote, the integrity of the educational process. Now, this is not Trump's first run-in with the law, and of course, there's a lot going on here. We're waiting for the judge to issue a ruling on this, but Trump and his team has submitted their final response to the so-called independent monitor, and she is doing an analysis of the Trump organization, and she's going to say, Your Honor, Judge Engoron, before you issue your communist decision, please make sure you understand what I found when I did my independent review of Donald Trump. And here is what that looks like. You see, sent over to the Honorable Arthur Engoron, Supreme Court of the State of New York, People versus Donald Trump. It says, Dear Judge Engoron. And the woman who's writing this, you'll see down here, is a retired judge. Her name is Barbara S. Jones, retired. And we're going to fly through this. We'll just hit the highlights, and then we'll hear Trump's response because he's going to respond to a lot of it, so we don't need to read it twice. But here's the background. She says, okay, Judge Engoron. And she's been doing this for a long time, since November 14, 2022, okay, for a long time. Here it says, I was appointed as the independent monitor, so-called, and I am required to report the status to the court. Now, to my date, my team has reviewed more than 3,000 documents. Lots of things. Financial disclosures, loans, documents about the structure and organization and entities, statements provided to Trump, taxes, transactions, and so on. Specifically, says this judge, I went through the Trump organization with a fine-tooth comb. We reviewed over 422 documents, 179 here, 200 bank statements, and blah. Now, they say, while the Trump organization, during this time of review, while they did not enter into any material loans or make significant real estate purchases, it submitted numerous financial statements, and I believe, Judge, that I have identified certain deficiencies in the financial information that I've reviewed. Now, while the Trump people, while they have been cooperative, information required to submit this has at times been lacking. So Trump is not letting them get everything that they wanted, according to this judge. Lacking in completeness and timeliness. And I have reviewed these items with Trump, and they've agreed to modify. So Trump is agreeing to modify their disclosures or to implement processes that improve accuracy, transparency, and the timeliness of their disclosures to some independent monitor who is appointed by a hack judge. She says, my duties include the monitoring of a bunch of things and to comply with the orders. So Engoron orders Trump to give this stuff to them. They're obligated to provide to the monitor a full and accurate accounting of everything. And she says, defendants are also required to give me all this stuff. Now, I'm very, special. She says, after my appointment, I met with a bunch of people. I will make independent inquiries, and this is the process. She tells us about the structure, about the purpose and the function. Now, of the 521 entities, which is a lot, 51 were dissolved, and they explain what's happening here. And let's get to her conclusions, and then we'll jump into Trump's response. But here are her observations, okay? She spent, the first 7 pages explaining it. What's your point? Okay. As stated above, my role has been limited to assessing the accuracy of the information that Trump gave to me. During my review, here's what she says. Now, Trump is going to respond to all these and obliterate them, but just so we see, I've identified instances where certain disclosures are either incomplete or demonstrate a lack of transparency, whatever that means. This is not a normal thing to have an independent monitor just demanding access to certain things, and you say, I don't think I should give you that, or I'm obligated under the court order to give you that. She says it's a lack of transparency, like they're lying or hiding something. I don't think that's accurate or fair. She might say I'm entitled to that, and Trump might say I'm not entitled to that, right? Just because we're talking about numbers and financial records and financial statements, I think a lot of people have a tendency to think that it's just numbers and it's all facts because it's numbers and it's math, right? Like it's just a spreadsheet. Everything has to calculate together and sum up right. But no, there's as much discretion in this stuff as anything. That's not required to be categorized that way. I don't have to disclose that to you. This doesn't go on that form. This goes on that form. Put this on any form. This guy says put it on that form. He says put it on that form. They say put it on that form. So I'm going to put it on all the forms. Whatever. Like that's just why we have generally accepted accounting principles, right? The GAAP stuff. And there's a lot of different interpretation for this, just like there is in the law with words. We can debate over the words, and the words are what tells you to put the things where. The words say put this here, put this there, but if the words aren't clear, you don't know what to do. So anyways, she says certain loan agreements require Trump to provide accuracy statements and so on. We identified 10 instances where the lender required this, but it was incomplete. All right, so Trump didn't give him an updated report on this. Or certain loan agreements require disclosures. We've observed that some of the contingent liabilities have not been included in the documents. They forgot a term or something. Inconsistent disclosures. Expenses related to management fees were inconsistently presented within the annual budgets prepared and submitted for for the lender. Maybe somebody who prepared the budget one year decided to put it in, the other didn't, right? So it's inconsistent. And there were also errors. The calculated amount of EBITDA was different. So there was a difference of 1.58 million there. So that's kind of a big number, right? She puts that near the top, 1.16 million. But some of these are other kind of small, an understatement by 14,000, an understatement by 130, whatever that is. We got in 2022 Doral audited financial statements and other things. Okay, so here's the final category, interactions with the monitor. Then we're going to jump into the Trump stuff. She says, as described, Trump failed to inform me of tax returns that had been filed for certain entities. And I was also not informed of cash transfers that were sent to Trump, each exceeding 5 million or more, until my team reviewed the accounts. So moving big money around. The Trump organization did not inform me of financial disclosures. And as mentioned above, the Trump organization sold its right to operate Ferry Point. And I did not receive this information until later, right? So she's upset I'm not getting the documents immediately. And so in conclusion, this is what she writes. Following the work my team completed, the above set forth my findings. It is important to note that Trump acknowledged the disclosure issues described that I brought in, and they're open to recommendations to improve accuracy and transparency. Like, yeah, that's a good idea. Maybe we should tighten that up. Indeed, during the monitorship, the Trump organization has actually already implemented changes, several of which are described above. In addition, with respect to instances where required disclosures were not provided, they submitted information when it was made aware of the omissions. So in other words, they did everything. They're like, okay, sure, that's a great idea. We'll do that, whatever. Now, does that mean the entire business should be dissolved? And by the way, if you went into any business, okay, even yours, they're going to find financial problems always, right? Oh, why is this going on here? It's not categorized the right way, whatever it is. Because that's the point, right? Nobody bats 100% all the time in anything. So absent steps, if you're going to get an audit, they're going to find something. So absent steps to address the items above, my observations, she suggests that misstatements and errors may continue to occur. And that could result in an incorrect or inaccurate reporting. And that's kind of the big problem. Could result in incorrect or reporting of financial information to third parties. And so the parties continue to cooperate with me under the requirements. If you have any questions, please feel free to contact me. Now, Trump says, okay, Barbara, judge, retired. Maybe if you weren't grifting millions of dollars off of us since you've been so-called independent monitor since 2022, we'd have a little bit more belief in your report, but you're not. Trump's team responds. They send this back over to Arthur Engoron, aka the NIP. They say, dear Judge Engoron, Areola, as you're aware, we represent the defense. We have something to say about this report. Now, the January 26th report, the one that we just read, issued mere days, we're waiting for a verdict, a decision any minute, has only two obvious purposes. To ensure that the monitor, Barbara, continues to receive exorbitant fees. Right now, she's got $2.6 million to date. Oh my gosh. That's a lot of money. So she's like doing all these audits and she's like, wow, yeah, I've noticed in your financial statement, you don't have my $2.6 million check. You better get that real quickly. Like, here. Now, Trump says, two, in addition to her grifting away, they are also filling the gaping hole in Letitia's case, not in the seat where she's been sitting for the last 6 weeks, which they're probably also going to have to repair that hole too on the bench as well. But in her case, not the courtroom pew. Now, namely, that there is no basis to support continued oversight. Get this monitor out of here. The January 26th report also contains numerous factual inaccuracies that even cast doubt on her competency. So whatever we read means maybe she's just a moron. She's a judge, by the way, right? Maybe not an accounting or financial judge, who knows? It also fails to reference governing standards of any kind, and it's misleading and disingenuous. Now, despite having reviewed thousands of pages of financial data relative to more than 400 entities and having paid millions of dollars for her so-called, quote, oversight, the monitor only points to minor and immaterial discrepancies and simple math errors. For example, millions paid so that the monitor can, quote, uncover 7 immaterial disclosure items that are irrelevant, right? That disclosure list, 3 irrelevant inconsistencies, don't even matter, and 5 clerical errors that nobody cares about. Now, moreover, the monitor issued 5 prior reports specifically advising the court and Trump and the org ongoing cooperation and compliance. Now, so in other words, they were saying ongoing cooperation and compliance 5 times before. Trump is cooperative, they're complying. But now, in obvious and bad faith effort to manipulate the innocuous accounting items into a narrative favoring her continued receipt of millions in excessive fees, now Barbara rehashes long resolved issues and, quote, for the first time includes the unabashedly self-serving statements that, quote, my observations suggest that misstatements and errors may continue to occur. Now, Trump entities cannot legitimately be held to a strict liability standard wherein immaterial inaccuracies or math errors form the basis for this ongoing oversight. Millions. Now, further oversight is unwarranted and will only unjustly enrich the monitor as she engages in some Javert-like quest against the defendant. And apparently this is from Les Miserables or something like that. I'm not French. The monitor was appointed to report any financial reporting misconduct, suspicious activity, and fraudulent activity. But not this. The monitor was not appointed to identify math errors or otherwise sensationalize minor and inconsequential accounting discrepancies scattered throughout the financial reports of over 400 companies. And that's it. That's what she got. She got like that. It's 12 pages, and half of the document is her whining or explaining herself, just so you can follow along. This is page 1. Explanation, things I looked at, how my team works, my review process, great. The structure of the Trump work, okay, got that. Financial statements issued to third parties. And then we finally get to her observations right here, right on page 7. And then she gets into it. 5 pages. And the concluding page is, let's see, that is, okay, it's a full page. So it's got 5 pages. That's it for 400 companies? Wow. $2 million bucks. Amazing. So pursuant to her appointment, the monitor submitted reports, all these back, all this one, December 19th, February 3rd, April 11th, August 3rd, November 29th, blah, blah. There is no mention whatsoever of any misconduct. Indeed, the words misconduct, suspicious activity, suspected fraud, or actual fraud do not appear in the report at all. She's just looking at spreadsheets. Now, instead, ignoring the letter and the spirit of her mandate, the report just rehashes resolved issues we already dealt with, and it also demonstrates fully that the only items that she has been able to identify in exchange for her $2.6 million are a handful of immaterial and irrelevant discrepancies and math errors. The fact that Trump and the organization have been forced to pay millions for a process which reveals there are no issues, there is no misconduct, there is no fraud is truly shocking. The fraud is $2.6 million being grifted away out of the Trump org. Now, the monitor wants to continue to perpetuate this. Now, until now, each of the 5 prior reports expressly recognizing that Trump has complied and that they have been cooperative. Here, they say, look, here you go, Judge. Ongoing cooperation. We appreciate this. Continuing to comply. I appreciate the ongoing cooperation. I appreciate the ongoing cooperation. I appreciate the parties' cooperation. And they continue to cooperate. But now she twists everything. The January 26th report, for the first time, now says that misstatements and errors may continue to occur. This is disingenuous. Now, they say also, Trump are simply not legitimately subject to this standard. The largest dollar item identified relates to the payment of taxes, fully and obviously disclosed in the bank statements, and it's not concealing anything. So it's not incomplete at all. In other words, all this stuff you can get elsewhere. In sum, the only possible purpose in this post-trial collective of immaterial items, why are they gobbling all this up and sending it to the judge? They're just going to bolster her disingenuous and self-interested efforts to frame Trump in a false light. These are discrepancies. These are framed out of context. And this was a detailed and expensive oversight inquiry, and this is all they found. Now, here are the purported incomplete disclosures. They go through one at a time. They say that this was not disclosed. That's not true, though. They say the court and the monitor are aware of this, that we don't do this anymore. The SOFC is no longer prepared. We don't even do this thing. Instead, the Trump entities prepared the MAML, which includes the material debt that has already been provided by Trump to certain lenders. No lender has raised an objection to getting this. Each lender has accepted it without incident. So this is a non-issue. She's like, where's this report? They're like, we don't do that. We already told you. The monitor also says this statement, now blah, blah, blah. This statement is also misleading. The alleged, quote, defect here is that a handful of the certifications did not include a manual signature line, okay? There was no manual signature line on the certifications. That's an omission of no consequence. Not a single lender raised any issue or requested a manual signature. Well, it needs to be an ink signature. Wow. A handful of them didn't have it, and nobody's ever complained. And she's like, well, there you go. Illegal. Take your whole business away. The monitor is not entitled to collect millions in fees, so she can substitute her judgment for an actual lender who accepts it. This is another non-issue and does not support her oversight. $2.6 million to say, can you please correct your signature line? Also talking about intercompany loans. But her deliberate mischaracterization casts further doubt on her competency and her veracity. It's another non-issue. The Trump entities, of course, never said the loan did not exist. We just gave her a memo saying that there are no liabilities. Now, the fact that she couldn't put one together is her problem. Saying the monitor has not disputed any of these facts, and it's another non-issue. So you see how this is working. Going through every single one and pointing out that this person is just not doing a qualified job. Here are some of the errors that they're finding. The monitor states that management fees were erroneously excluded, but this statement lacks context, fails to acknowledge the fact that the amount in question falls well below their own materiality threshold. Trump has already responded. In other words, this was simply a clerical error that was caused by cutting and pasting from an Excel file. That's it. She's auditing their Excel spreadsheets for millions of dollars. Now, the underlying income and the expense line items shown on the schedule are always properly disclosed and correct. Minor clerical errors do not support continued oversight. Again, another minor error on this one, and it's the same story as we go through. Now, they talk about interactions with the monitor. They say that the Trump organization, she says, they failed to inform me of their tax returns. But they say, well, the monitor, Barbara, she asked for the status of the appraisal in November, and we responded immediately by uploading it to her ShareFile site. So as soon as she asked, she got it, Judge. And similarly, the monitor acknowledged the ambiguity, and she knows that the transfers that she had questions about were for payment of taxes because they were fully disclosed in the bank statements that were provided to the monitor by the defendants. So in other words, she's saying, I don't see stuff. She says, I was not informed of the cash transfers, right? Judge, they didn't tell us about $5 million going to Donald Trump. Trump got 40 million bucks moved in $5 million increments. They didn't tell me about that. They say this is totally misleading. The Trump entities discussed this with her on November 28th. Materiality threshold only required telling her this stuff anyways. But we acknowledge this ambiguity, and she knows because it was in the bank statements. Like we gave her the bank statements saying, hey, here's the money moving around. So they say that this is appalling disingenuity. She is being disingenuous because she had the records and I didn't see any of this. She's also upset she didn't get these records. And they told her specifically, Trump entities expressly informed her, quote, there were no financial disclosures of any kind provided to the insurance broker. This was affirmed in writing. We shared it with you. Okay, so she's just kind of picking and choosing, and you can see how this concludes. Now, as noted, Judge Engoron, Areola the Nip, Barbara has thus far been paid, check this out, $2.6 million in the past 14 months. 14 months, $2.4 million. That's nice, man. It's nice work if you can get it. How do you become a monitor in a corrupt, broken city for corrupt partisan hacks? How do you do that? You can get paid $2.6 million if you can get that job. To uncover, quote, 7 immaterial disclosure items that no one cares about, irrelevant inconsistencies, and 5 clerical errors that she found in spreadsheets. Now, after representing that Trump was fully cooperative and compliant this entire time, now she desperately, Barbara, seeks to justify the continued receipt of millions of dollars in fees going forward. And so, setting aside her self-serving hyperbole, the monitor, Barbara's own findings simply do not support or provide any evidentiary basis for continued oversight. Indeed, the monitor did not identify any financial reporting misconduct, suspicious activity, or any suspected or even actual fraud. All of her conclusions are based on subjective determinations devoid of any standards or considerations of any established frameworks or rules. And she doesn't identify that any of these deficiencies were even material. And so, moreover, Barbara herself acknowledges that the minor issues she has identified could be remediated with an effective process for review and, quote, training. Methods far less expensive and less intrusive than continuing, ongoing, and pointless oversight by Barb. The court, therefore, must and should end this abusive and costly process. Should the court have any questions, Areola, let us know. Signed by Clifford Robert on behalf of the Trump org. And what they're attaching here in the rest of these exhibits, as you can see, this will be available at robertgovea.com, is all of the other letters, right? So, hey, dear Judge Engoron, on December 19th, she wrote a different thing. And she says, you know, back in here, that everybody's very cooperative. She said, in the prior order, defendants are complying with the terms of the order, and I appreciate their ongoing cooperation. Honorable Barbara Jones, retired. All sent over to Judge Engoron. And now you can see we're waiting for a ruling from Judge Engoron, a decision. What's he going to do when this all comes out? And so let's get into that when it does. Of course, before we exit, we got to make sure we hear from Alina Abba, who's in the house, and she's explaining that they're going to be appealing this. They're not waiting around. They need to appeal this based on conflicts of interest in the E. Jean Carroll case. But here is what Abba says in a summary of what the Trump cases look like currently.
On the federal front, it seems that the trial timeline is aligning very closely with the primary elections.
Yeah.
What do you think is going on there?
Shocking. Isn't it shocking? It's shocking that he's going to be tied up in court. You know, it's like what I said before. They can't beat him. So they have to use, corrupt methods, lie, cheat, and steal. And part of that is tying him up in court so that he can't be out in Iowa and he can't be out where he needs to be campaigning. Whether they win or lose, they don't care. They've already, in their mind, done what they've wanted. And I think they would go so far as to try and put him in jail if they could. And it's a very frightening time. It's motivating the Republican Party, but it's a frightening time. And we'll just take each one head on.
For my final question, if there's one overall important thing that you would like people to understand about what's going on here in a nutshell, what would that be?
The president has done nothing wrong in these cases. I know these unbiased cases. This is absolutely what he would call a witch hunt, but more importantly, election interference. So we have to overcome that. We have to get out and vote. And don't let it waver your faith. He's tremendous, and he'll get back in and clean it all up.
So that is Alina Abba, and we have another clip from her saying that they are scared of Trump. Let's listen to this.
As President Trump's lawyer, you and your team have been facing relentless left-wing lawfare, 91 charges in 4 separate cases. How do you guys remain relentless in the face of all that?
Motivated to save the country. I think that has a big part of it. Lawfare is a real thing. We're seeing it. You know, they can't stop him with the votes, so they're trying to find other ways and get creative, and they've used the justice system, unfortunately, to do so. So, you know, we're motivated. We have a great team.
Alina. This is a family show. Someone's going to have to get me an ice pack.
And the facts are on our side. The law is on our side. The problem is that we have corruption and politics permeating our judicial system. So as long as we can get some people who really put their robes on and take it seriously and get rid of some of the corruption in these, you know, Soros backing AGs and DAs, we'll be okay.
What is your message to people who might be saying, you know, I'm just so sick of all this that's going on and I just want it all to go away?
Well, you know, we have to fight. You can't expect things to just go away. If you care about the Constitution, if you care about the country, get up and vote. That's what individuals can do. Don't think that, you know, your state's red, so you don't have to go vote. You got to get up, you got to vote, you got to do your part. So it's very important, and I think that they should, you know, don't despair. We only have a little bit more time left, so everybody, if anything, we've got to get charged up.
That's right.
It's, you know, November's around the corner, and
She's right.
I'm looking forward to seeing President Trump win.
When it comes to the civil fraud case in New York, several legal experts like Jonathan Turley, Andy McCarthy, Saul Weisberg, you know, they've said that this is obviously a political prosecution.
Yep.
What kind of precedent does that set, and what kind of
It's
implications
dangerous.
for the Republic does that?
Very dangerous for New York, the state of New York. They used a consumer fraud statute, and they used it in a private business. They went into contracts where no one was harmed. There's no victim. Everybody made money. They made money quickly. Loans were paid off. They were never in default. They're trying to get rid of the Trump organization to hurt financially the leading candidate of the Republican Party. So if you're in the state of New York, honestly, you should be very concerned. We're seeing Letitia James, who ran on getting Trump, get Trump. That's a problem. That's not the way this works. You don't get to say, you're going to go into office, and this was her quote, go into office, get Trump, and go home. You know, you can't do that. It's un-American. It's not the way AGs are supposed to operate. They're supposed to protect the city. And meanwhile, the state of New York is falling apart. Crime is rampant. So it's very destructive. I think for the state of New York, for businesses, small businesses, private businesses, this will set a very dangerous precedent.
She's right about that, and I do appreciate her saying that we do need to be charged up. You know, a lot of these things, and I'm sure you can feel it too, they can be very deflating when you hear people, as we'll talk about in the next segment here, you know, like E. Jean Carroll and others doing victory laps, doing cartwheels every time they have a new little battle victory. It becomes an energetic deflation, you know, in many areas, and of course, that is the intention, right? They're trying to beat their enemies. They're trying to diminish the energy levels of the other side, and we're not going to let that happen. We're going to keep exposing these people for who they are, because they can't do this stuff fair and square. They've got to have 2 judges. They've got to use bizarre laws in new ways that have never been applied in these instances. They have to bring cases where there's no victims, right? They can't beat Trump fair and square. They know he's got the entire large part of this country at his back, and it is now break glass in case of emergency. Pull out all the stops to make sure that he cannot win. Go after his businesses, go after his family, his kids here in these businesses, the organization that has built literal buildings in New York, saying you guys just have to just go away now because you are Trump. You are not part of Tishy's vision for America. And so we're going to be here continuing to cover this, my friends. Thank you for subscribing wherever it is you're watching this. If you want to grab the PDFs that we went through on this segment, they're available at robertgovea.com. Stop by the shop while you're over there to grab a hat, and we'll look forward to seeing you back here on the next one.